Here's a sentence that should be impossible in America, and yet lawyers hear it every single week. Dad has money. Dad has a house. Dad raised us right. And right now, none of us can legally do a single thing to help him. Because here's the cruel math of legal documents. The day you need them is the exact day you can no longer sign them. A stroke, a dementia diagnosis, an accident. The moment a doctor questions your mental capacity, your pen stops working, legally, forever. And your family's only remaining option is a courtroom. Surveys consistently show that most American adults don't even have a will. And among those who do, most are missing the 4 other documents that actually matter while you're still alive. So today, I'm walking you through the 5 legal documents every senior needs, what each one does, the horror story that happens without it, roughly what it costs, and the mistakes that make even signed documents worthless. Stay for number 5. It's the one document almost nobody has heard of. It costs almost nothing, and skipping it can lock your own children out of your hospital room information. I'm not a lawyer, and this is education, not legal advice. State laws differ, and I'll tell you exactly where to get real help cheap or free at the end. Let's start with the one document everyone thinks they understand, and most people get wrong. What it does. Your will is your voice after you're gone. It names who gets what, and, critically, it names your executor, the person in charge of carrying it all out. If you have minor grandchildren in your care, it can also name guardians. Now let me tell you about a man I'll call Frank, a composite of 1,000 true stories. Frank was 74, owned his house outright, had 2 grown kids who loved him and, importantly, loved each other. Frank always said, "I don't need a will. The kids will figure it out. They're good kids." Frank passed without a will. And here's what "the kids will figure it out" actually means in America. The state figures it out for you. It's called dying intestate, and every state has a rigid formula, a one-size-fits-all family tree that decides who inherits in what percentages, with zero regard for what you wanted, what you promised, or which kid drove you to every doctor's appointment for 10 years, while the other one called twice a year. Frank's good kids? They started as good kids. Then came the house. One wanted to sell, one wanted to keep it. No will meant no instructions, no executor, no referee. 18 months and 2 lawyers later, they got their inheritance, smaller, and lost something the court couldn't give back. Thanksgiving together. 3 things people get wrong about wills. 1. I don't have enough money for a will. A will isn't about being rich, it's about being clear. The smaller the estate, the more damage a family fight does to it. 2. I made one in 1994, I'm covered. A will is a photograph of your life the day you signed it. Divorce, remarriage, a child's death, moving to a new state, a falling out. Any of these can make an old will worse than none. Rule of thumb. Reread it every 3 to 5 years, and after every major life event. 3. And this one's the sleeper. Your will does not control everything. Your retirement accounts, life insurance, and any account with a named beneficiary, skip the will entirely. Hold that thought. It's coming back with a vengeance in a few minutes. Cost reality. A straightforward will from an attorney commonly runs a few $100s. Reputable online services, less. Complicated family or assets? Pay the attorney. It's the cheapest fight prevention money can buy. The durable financial power of attorney. If the will is your voice after death, this document is your voice while you're alive but can't speak for yourself. And I'll say something bold. For most seniors, this document is more important than the will. What it does. A financial power of attorney, POA, names a person, your agent, who can legally handle money matters on your behalf. Pay your mortgage, manage the bank account, deal with the insurance company, sell the car, talk to the IRS. The key word is durable. A regular power of attorney actually dies the moment you become incapacitated, the exact moment you need it. A durable POA is built to survive your incapacity. One word in the document. Everything hinges on it. Now, the horror story. And this one keeps elder law attorneys up at night. Picture a wife of 52 years. Her husband has a major stroke. The mortgage, the utilities, half their savings, all in his name, because that's how their generation did it. She goes to the bank to move money for his care, and here's the sentence that breaks thousands of families every year. I'm sorry, ma'am, you're not authorized on this account. Married 52 years, not authorized. Her only path now? Petition a court to declare her own husband legally incapacitated and appoint her his guardian or conservator. That means attorneys, medical evaluations, court hearings, months of waiting, thousands of dollars, and afterward, in many states, filing ongoing reports to a judge about how she spends her own family's money. A public court process for a private family matter forever. All replaced by one document that would have cost a few $100s on a Tuesday afternoon. 3 landmines to avoid. Landmine 1. Choosing on autopilot. The agent doesn't have to be your oldest child. It should be the most organized, most honest, most available person. And name a backup, because life happens to agents too. Landmine 2. The springing trap. Some POAs only spring into effect when you're declared incapacitated. Sounds safer, but who declares it? How many doctors? Banks hate ambiguity and often refuse springing POAs while lawyers argue. Most elder law attorneys prefer an immediately effective, durable POA held by someone you truly trust. Because if you don't truly trust them, that's a different problem no document fixes. Landmine 3. The stale POA. Banks get nervous about documents older than a few years. Refresh it periodically and ask your own bank if they want their in-house form signed too. Annoying? Yes. Cheaper than court? Infinitely. The healthcare power of attorney. Same concept, different battlefield. Who speaks for you medically when you can't? This document, called a healthcare power of attorney, healthcare proxy, or medical POA, depending on your state, names the person who makes treatment decisions on your behalf. Which surgery, which facility, which specialist, continue or stop a treatment. Without it, here's the mess. Most states have a default pecking order, spouse, then adult children, and so on. Sounds fine until you have 3 adult children with 3 opinions and a doctor who needs an answer today. Or a decades-long partner you never married who legally ranks below a nephew you haven't seen since 2009. Or 2 kids who agree and 1 who threatens to sue the hospital. When the family deadlocks, guess where it goes? Same courtroom as before. The document is only half the job. The conversation is the other half. Naming your daughter means nothing if she has no idea what you'd want. So after you sign, have the uncomfortable dinner. Tell your agent how you think about quality of life versus length of life, about nursing homes, about what do everything means to you. Give her the gift of certainty, because the cruelest thing you can leave a child isn't a decision. It's a decision plus doubt. And pick one decision maker, not a committee. You can require your agent to consult the others, but when the doctor needs an answer, one voice answers. Democracies are wonderful. Hospital hallways at 2 a.m. are not the place for them. The Living Will/Advanced Directive. Document 3 named Who Decides. Document 4 is what you've already decided. A living will, often bundled into an advanced directive, is your written instructions for end-of-life care. If you're terminally ill or permanently unconscious, do you want machines to keep you alive? Feeding tubes? Resuscitation? Comfort care only? Why does this deserve its own document when you've already named a healthcare agent? 2 reasons. Reason 1. It takes the weight off your family. There is a specific kind of guilt that haunts people who had to make the call for a parent. A living will transforms your daughter's role from decider to messenger. She's not choosing to stop treatment. She's honoring your choice in writing, in your words. Families that have this document grieve. Families that don't have it grieve and fight and second guess for years. You've seen the famous cases that ended up on the news, with siblings and spouses battling in court for years over what someone would have wanted. Every one of those wars could have been prevented by a few pages. Reason 2. It speaks when your agent isn't in the building. Ambulances, ERs, out-of-state hospitals, your instructions travel even when your people can't. Practical notes. Every state has its own statutory form. Many are free from your state's health department or bar association website. Give copies to your agent, your doctor, and the hospital. And if you have strong wishes about resuscitation specifically, ask your doctor about a POLST or DNR order. That's a medical order, a level beyond the directive, and it must come through a physician. The HIPAA Authorized. And now, the little one almost nobody has heard of, the one that costs nearly nothing and causes outsized heartbreak when it's missing. HIPAA is the Federal Medical Privacy Law. Wonderful law. It keeps strangers out of your medical records. The problem? Without your written permission, it also keeps out your own family. Real-world version. Your son calls the hospital. "How's my mother? What happened?" And a very polite voice says, "I'm sorry, sir, I can't share patient information." He's not asking to make decisions. He's asking what's wrong. And the law, doing exactly its job, says no. The HIPAA authorization is a simple form listing the people allowed to receive your medical information. It's not decision power, that's document 3. It's information access. Name your spouse, your kids, whoever you want kept in the loop. Why it matters, even with a healthcare POA. Many healthcare POAs only activate when you're incapacitated. But suppose you're conscious, medicated, and confused after surgery, not incapacitated, just not up to relaying details. Without HIPAA authorization on file, your family can be reduced to guessing from the waiting room. It's often a single page. Many attorneys throw it in free with the other documents. Some hospitals have their own form. Sign it during any pre-registration. 1 page, 5 minutes, and your family never stands in a hallway being told your health is none of their business. The bonus that outranks them all. Plus, wrap-up. Remember the thread I left hanging in the will section? Here it is. The 6th item that isn't a document in a drawer, but quietly overrules your will. Beneficiary designations. Your 401k, IRA, pension, life insurance, and any bank account marked payable on death go to whoever is named on the form, not whoever is named in your will. The form wins. Every time. Which is how the classic American estate disaster happens. A man remarries, updates his will lovingly for his new wife, and his ex-wife from 1998, still named on the old 401k form, inherits the largest asset he owned. Courts have upheld exactly this again and again. The form wins. So here's your 30-minute homework this week. List every retirement account, insurance policy, and bank account. Call or log in. Confirm the primary and contingent beneficiary on each. Fix what's stale. This costs $0 and prevents more heartbreak per minute than anything else in this video. Now, the full kit, 1 line each. A will, your voice after death, and the referee your kids deserve. A durable financial POA, so your family never hears you're not authorized. A healthcare POA, one trusted voice when doctors need an answer. A living will, so your family carries out your choice instead of carrying guilt. A HIPAA authorization, so no one you love is locked out of the loop. plus beneficiary forms, checked, current, and contingent named. Where to get it done without going broke. An elder law or estate attorney typically packages all 5 for a flat fee, often less than people fear, and worth it for blended families, real property, or any complexity. On a tight budget? Your state bar association lists low-cost clinics. Many area agencies on aging run free document days, and legal aid programs serve seniors specifically. What matters less is where you sign. What matters is when, because every document in this video has the same expiration date, the day your capacity comes into question. None of us gets a calendar warning for that day. If you're watching this and you're the senior, you've spent a lifetime protecting your family. These 5 signatures are the last, best act of that protection. Do it while it's cheap, easy, and entirely on your terms. If you're watching this and it's your parents who need these documents, forward them this video and then offer to book the appointment and drive them there. Not, you should really do this someday. An actual date on an actual calendar. Someday is where these documents go to die. Tell me in the comments, which of the 5 do you already have, and which one did today convince you to finally get? I read every single one, and your questions become future videos. Subscribe to Senior Wealth Academy. Next up, wills versus living trusts. Which one your family actually needs, and who's wasting money on the wrong one? You spent decades building it. Let's make sure it protects the people you built it for. See you in the next one.